I will say this, that it's the legislature that is enabling this with the nature of the act, and there is a perspective that has been lost because, as you say and say very correctly, we have supported many families over the years. We have contributed to our community. We have contributed to the economy of our community, and to be dealt with in this fashion, that in such a punitive way, is seems to me a real loss of policy perspective.
Right.
I'm at loss to understand what they are thinking with the PAGA framework. Mm-hmm. What are they thinking?
Welcome to the California Labor Law Odyssey. My name is Tom Manzo, and I'm the president of the California Business and Industrial Alliance. We're a nonprofit organization that was formed to bring awareness to the widespread abuse of the Private Attorneys General Act, better known as PAGA. PAGA was signed into law by Governor Gray Davis back in 2004, and since has been used to extract hundreds of millions of dollars from California's businesses under the virtuous banner of employee advocacy. What people don't realize is that those millions of dollars never went to the employees. It went to the shark lawyers and to the state of California. These sharks aren't recovering lost wages. They're looking for small mistakes they can build up into a class action lawsuit. You see, attorneys' fees are protected under the Private Attorneys General Act, so they can charge whatever they want, but they only get paid if there's a settlement. Their end game is always a big settlement, never a trial. This is not justice, and we're here to expose it. Today, we're going to have as our guest Nick and Christina Vasels, and they own a restaurant, and we're going to discuss with them their business and what they're faced with, and unfortunately, another victim of PAGA. So, Christina, if you'd like to introduce yourself, I'd appreciate it.
Hi, I'm Christina, and I've owned Paco's Mexican Restaurant and Bar since 1996. And we're 8 furlongs away from the Santa Anita racetrack. We have been in business. Actually, the restaurant is 74 years old, and I'm the third owner of this restaurant. And I'm a woman running the restaurant pretty much on my own. My husband assists me with human resources and legal matters.
Well, welcome to the show. Nick, thanks for coming on the show. Looks like you're enjoying the backyard today.
I am, and working at the same time, but in a very pleasant environment.
Right.
Of course, as Christina mentioned, I mean, we're married, and I help her I'm an attorney, and I help her in legal matters. I act as general counsel for companies, and
these days, if you own a business, it certainly doesn't hurt to have your spouse as an attorney. So I'm sure that's a bonus there. So how many employees do you have at the restaurant?
Average is 30, because I had quite a few students and mothers, so I had quarter timers and part timers, and then I had a core group of 15 that were full time.
Yeah. And I think what happens is a lot of people don't really understand, especially legislation. Part-time employees are always going to be needed, but part-time employees are normally the most difficult to manage, because you have to be so cautious on the amount of hours they work, and if they work only 6 hours, you don't have to worry about a lunch. If they work 1 minute past 6 hours, then
correct,
they have to take their lunch, and there's just a lot of rules and regulations that go along with that. So you're the third owner of this restaurant. So how many years has this restaurant been around?
It started in 1947 by Mrs. Hanetta.
Wow.
And I was the third owner. And basically in this business, unlike corporate America, an office where I worked for the Capital Group in downtown LA, it's like herding cats. I always told my husband, started analyzing, he goes, oh no, it's not herding cats, it's herding blind cats.
When I was back in Detroit, one of my first jobs, I believe I was 14, I started washing dishes for a high-end Chinese restaurant. And it was a lot of work. And I think about the days, like the weekends when we were busy and slammed. You know, you worked through breaks and you didn't take things on time, but you know, they treated me great because you could eat when you wanted to, you could eat whatever you wanted to. And it was kind of a family type atmosphere. And I think I learned a lot. I think I learned a very good work ethic, you know, coming from that restaurant industry. And the rules and regulations that they put on restaurants really make that so difficult. I think it's one of the most difficult businesses to manage in California, and it's because of the labor laws. I think it's almost impossible.
Well, California's changed since I bought the restaurant, and I actually had a good break system. I mean, we had it in writing. I mean, and people followed it because they enjoyed it, and they took their 30 minutes. We have a beautiful banquet room. I mean, there's movies of my staff. We have them on video camera, enjoying piles and piles of food and watching their favorite shows and taking their full 30 minutes. But it's just a few people that thought they were going to, you know, win a lot of money. Most of my employees have been with me on an average 20 years, and they're horrified by what happened by a 10-year employee, and it was staged. And so everyone's pretty upset at the restaurant, and it's cost me quite a bit of money for absolutely nothing. My employees always took their breaks. Most of them clocked in and out on time. They actually took the full 30 minutes, and they received free food. And we were pretty methodical, and we had handbooks. We had signed handbooks. We had everything you could imagine, not just from most recently, but even in '96, I was a stickler about their meal breaks because I worked corporate. When I have a master's in finance out of USC, and when I was employed, they were very strict about meal breaks and clocking in and clocking out. And I picked that up and I brought it to my restaurant. So I'm really in shock how, you know, I ran the restaurant very professionally with warmth, like a restaurant family, but then I wanted my employees to really enjoy our food because they are the marketing agents of the product, and the product is food and liquor. And I would make sure they tasted the food and they could order anything they wanted. I wasn't strict. And we had one employee who was pretty much disgruntled because I didn't make him general manager, and he staged this whole event. And people told me in my organization, he was having parties telling people not to clock in or out. And we didn't even have, there was just a group of people that they would just say they forgot. And they signed affidavits saying, I just forgot. But meal breaks were enforced, or meal breaks, I know I was supposed to take it, but I just forgot that day. And they actually signed affidavits saying that. And we heard from the employees that many were told at some parties to stop clocking in and out. So it was a total setup.
I think most employers, 95% of them are trying to do what's right. They're trying to create this family type atmosphere. And, unfortunately, when you have a family atmosphere, sometimes you're a little bit looser on things. And when you are, that's when you have trouble. I mean, you have an 1,100-page labor law digest that really becomes almost impossible for anybody to follow. I mean, Nick, you're an attorney. I mean, I don't think there's another state that has a labor law digest as thick as California's, is there?
There's another issue too. And you probably encountered this in your own experiences. Many restaurant employees, particularly servers, prefer not to take their meal breaks. They don't want it. They don't need it. They don't want to abandon their tables and want the tips.
Right.
And it's not important to them to take time. One of the things that, speaking from a legal standpoint, that I am at loss to explain is that in PAGA, at least in the particular action that we experienced in the court that we dealt with, which was downtown LA, the basic principles of the Brinker decision were not were really disregarded. We have a situation where there was never an issue of our policies and our affording the employees, their right to take a meal break and encouraging them to do so. And they took their meal breaks. I mean, what it came down to is a matter of, in our case, is several failures to properly clock in and out. But the informing them of their right to take a meal break, affording them the opportunities, having the written on every day, having the written policies to back that up, were somehow all disregarded by the court, and that is disturbing to me. In the context of employees really preferring, to work through meal breaks, for which they were paid, by the way. There's no issue with that. I think that, there really is a very dated application of the law to achieve the results that they seek, and those results, of course, and are the enrichment of the lawyers and not the plaintiff class representatives that they purport to represent. The attorneys make all the money here.
The Brinker case pretty much said, as long as you always make lunch available, at the proper time, there should not be a violation if the employee on their own decided to take that lunch a little bit later or decided not to take that lunch.
Exactly.
But unfortunately, in the real world of a lot of these lawsuits, the person will say, well, the manager told me not to take that lunch. I was going to, or, I thought I had to work through my lunch. And all of a sudden, Brinker goes right out the window, which it was a good decision, but I don't know how much it really does help in the scheme.
It didn't help. And the best part for me, I went to the trouble to pull all the meal tickets. See, I talk about encourage breaks. I offered them free food and anything off the menu. There was really nothing they couldn't really order. Unless they were abusing it, like ordering a steak every week or every day. But just, they could taste almost anything on the menu. And I had free meal tickets the time they took the meal, but no clock in and out. And that was hard evidence that was totally disregarded. It's like, I can prove they ate, and they ate for free because of the time the order taker or the cook put in the employee meal. And it's like employee meal and the time, and it's attached to their name. It would say the person's name. And that was not, to me, that was hard evidence that they took their break and obviously forgot to clock in and out or purposefully, but it didn't seem to help. And I had approximately every month $2,000 worth of these kinds of tickets.
Wow.
A lot of money. I was told that was, and I hired a paralegal on my own and a bookkeeper. I spent all this forensic money, and then I paid a forensic another $10,000. I had beautiful evidence to prove with beyond a reasonable doubt that we're not sure here. It looks like this might have been purposeful.
When did the PAGA suit start? What date did that begin?
October 2017, wasn't it?
Well, that's when they sent the pre-PAGA notice. The lawsuit was actually commenced in February of 2018. And so an LA firm took the defense. And I don't want to name the firm because I don't have good words to say about them. They were not at all sensitive to some of the facts that, in fact, all the facts that Christina is saying, and they did not have a heart for advocacy, and they were too quick to settle on this thing. I wish that the case had gone on because I think that some of the issues would have been very, litigating. But in any event, it is what it is. We arrived at a settlement agreement about a year and a half ago, January of 2019. But it is yet to be implemented and even approved by the court. So that's where the case stands.
Nick, just going back to everything, so what was the original amount that they asked for on this lawsuit?
They sued for $4 million.
Now, can you disclose what the settlement amount is going to be now?
Yes. The settlement amount is $300,000.
And I'm praying the judge does keep sending it back. Pray with me, Tom and Nick.
I think all of us will. So, I mean, my God, $300,000 over late lunches, not to mention, all the stress and the time, and the other money that you spent, the time you
$4,500 a month on free food to my employees.
Yeah.
They ate it. We have the time in that they took the food, and they sat down somewhere and enjoyed it. And we have movies and videos, $4,500 a month retail. And we have that evidence, and it didn't even matter.
The one thing I would ask of Nick really quickly is if you were to say something to legislation, the lawmakers.
I would like to tell them to abrogate the private attorney general action process altogether. This is a matter that is, these are claimed labor code violations. They should be handled by the labor board. The labor, that agency of the state that's their job.
Christina, how about you? What would you say?
I think it should have been taken only to the labor board. They deal with labor issues. They're more sensitive to employees and employers. They have a more real perspective. They hear cases every day. They're trained this way. And I think it should be a fix-it ticket.
I agree. So I guess my last question is, how are you guys surviving, as a restaurant right now with COVID and everything?
We're just keeping the electricity on. And thank God that I'm a little squirrel and I saved a lot through the years and I didn't spend because I always thought the restaurant comes first. I have employees to pay. And unfortunately, I never dreamed in my life that the life savings of the restaurant would be spent on a lawsuit. Never thought that. And all I can say is Wells Fargo Bank has been kind to me with credit lines, and we're surviving by borrowing money.
Wow. Well, I got one last gift for you, and I'm going to mail it out to you. But, everybody, you get these lawsuits, and I say, business owners like yourself, I mean, you're the salt of the earth. You should not be getting lawsuits from the state by deputized trial attorneys enforcing their laws. You should get a medal. So I'm going to send you a medal. The California Business Law.
Oh, thank you.
A medal on you. So
thank you.
You guys, we should be blessed to have business owners like yourself. And
I will say this, that it's the legislature that is enabling this with the nature of the act, and there is a perspective that has been lost because, as you say and say very correctly, we have supported many families over the years. We have contributed to our community. We have contributed to the economy of our community, and to be dealt with in this fashion that, in such a punitive way, seems to me a real loss of policy perspective.
Right.
I'm at loss to understand what they are thinking with the PAGA framework. What are they thinking?
Christina and Nick Vasels have operated Paco's Mexican restaurant for many years. They want their employees to feel good about where they work. Employee meals are provided and it's a friendly atmosphere. Unfortunately, PAGA doesn't protect employers from fraud. If an employee deliberately abuses the labor law, the outcome can be very costly for the business owner. It's hard to imagine an employee would deliberately avoid clocking in for meal breaks just to create grounds for a lawsuit. It's doubly incredible when he involves his co-workers in the same scam. But it happens. The Private Attorneys General Act fails to protect both parties, and that's a big problem. Labor disputes should be handled by the public servants of the California State Labor Board. That way, any fraud would be uncovered and dealt with in a fair and efficient manner. A $4 million lawsuit and 2 years of litigation? Are you kidding me? Who will restore justice in California? Will you?